Good morning and welcome to the National Government Ethics Virtual Summit. I'm Patrick Shepard.
And I'm Ryan Segrist, and we're very excited to bring to you today an introduction to conflicts of interest.
And this is the first in our series of virtual-only broadcasts that are going to be taking place throughout the month of September. And this is similar to something that we've done at previous National Government Ethics Conferences. Would you like to explain that a little bit, Ryan?
Sure. At previous National Government Ethics Conferences, we used to do something called a new ethics official track, which was a series of courses that were designed and new to the practice of government ethics. And the idea was that people who were new could attend this track and basically receive the canon and get the basics on how to do their job.
So this is really an orientation for those folks who are new to the practice or have been out of practice for a little while and would like to be reoriented to the body of ethics laws and regulations with every day. So we've selected some topics that are really fundamental, the things that come up most often and are most important in the day-to-day practice of new ethics officials. So what are we going to be talking about during our virtual broadcast series that will be mirroring the new ethics official track?
So, like I said, today we're going to be doing an introduction to conflicts of interest. From now until noon, we're going to be covering part of 18 U.S.C. 208, which is the mother of the conflict of interest statutes.
That's right. So we're going to be ticking off a number of the elements. We're going to come back after our break at 1 p.m., then that's Eastern Daylight Time, and cover the rest of the elements for 18 U.S.C. Section 2, as well as some brief information about how to remedy potential financial conflicts of interest under the statute.
That's right. And tomorrow, on September 12th, we're going to be doing sort of the same thing, but with 2635.502, the impartiality regulations.
And our colleague Cheryl Kane-Piasecki will be with us here in the booth at OGE, discussing the impartiality reg, the elements and things that you want to consider when applying it. It's not an accident that we are covering these topics in that order. We begin with the criminal conflict of interest analysis, and if we resolve all of the possible criminal problems, we move on to regulatory issues. So that's what we're going to be doing. So this might mirror something you would see in a financial disclosure review or other advice and counseling scenario where you're concerned with either financial conflicts or impartiality.
And for the rest of the month, just to give you a heads up, we're going to have several other virtual-only bonus sessions that we're going to do. On the 16th and the 17th, we're going to do 4 sessions on the gifts regulation, because that's something that is maybe one of the most common things that comes up in your ethics practice.
And those of you who are repeat viewers, you might know that we spent August doing the month of gifts. We covered a lot of gifts topics, but some of those were more advanced. So if you want to go back and learn some more about the fundamentals, we're going to be really starting with the reg, looking at the elements, and working through that.
So if you have not had your fill of gifts yet, be ready.
Yes, you will after next week.
Also, as a reminder, on Friday of next week, September 19th, we're going to be live streaming at the National Institutes of Health Forum Day number 2.
Yeah, so we'll be back there. We are there on Tuesday. Those of you who are watching on Tuesday, and I understand there were quite a few of you, thanks for letting us know that you were dropping some frames during the broadcast. We've identified the issue with the network settings and think we'll be able to bring you a higher quality, more consistent stream on the 19th.
That's right, and hopefully the fix that we have in mind will give you a smoother experience with, as Patrick said, less drop framed, less having to refresh all the time and all of that.
Yeah, so that should be a really exciting presentation. And then we're back on Tuesday of the following week for the last day of the virtual forum.
That's true. But Patrick forgot that the day before that,
on the 22nd.
On the 22nd, on Monday.
We have some very exciting presentations for you.
That's right. We have 2 virtual-only bonus presentations, one of them on regulations applicable to non-career employees.
Non-career employees, and that's a huge body of regulations. And our colleague Monica Asher has done a lot of research and a lot of study on this issue, and we'll be sharing with you a job aid that can be enormously effective when you're advising non-career officials. I think with those folks, especially if you don't have lots of non-career officials in your agency, you can go a long time without having to think about the rules applicable to non-career employees, not advising a non-career employee, and having a place you can go quickly to see the regulations that apply in a peculiar or specific way to those folks is an enormous benefit.
That's right, and what we're hoping with this session is that you won't have to just back and reteach yourself over several hours how to deal with this kind of thing, that you'll have a resource available to you right now to kind of help kickstart your memory and make that advice and counsel process for your non-career officials much quicker.
And we're also going to be doing a number of other things, right, Ryan? We're going to spend some time on the 22nd talking about ways that we can advise and train senior officials, because without the benefit of leadership support for your ethics programs, very, very difficult to run an effective program.
That's right, and what we're hoping to do with this is to give you some strategies, some tools to better your presentations for your senior officials,
and some suggestions about topics that you want to emphasize, and how to emphasize the role of those senior officials.
That's right.
In the ethics program, because ultimately the ethics program belongs to the agency. Ultimately, the agency head is responsible, and we want to show you some ways that you can help your agency be effectively run with respect to the ethics program, and some ways that your agency leaders can support your ethics programs effectively.
And then, as Patrick mentioned, on the 23rd, we'll be closing out the National Government Ethics Virtual Summit with a live stream at the Federal Housing Finance Agency.
Yeah, so we'll be there all day. I will be providing you some booth commentary, as well as all of the sessions scheduled for that day in the main auditorium there. And we have some excellent guests coming up there, so we look forward to seeing you on the 23rd to close out the National Government Ethics Summit.
All right. Get into our presentation now?
I think that's a good idea, Ryan.
Okay.
So let's take a look at the slides, and we can begin talking about the elements of 18 U.S.C. Section 208. So here we go. We're in Part 1 of 18 U.S.C. Section 208, and we're going to be discussing conflicting financial interest. That's the concept that the statute deals with. It's the prohibition. We have a prohibition on participation in government matters where an employee has a financial interest. And we're going to take the general text of the statute today, and we're going to dissect it and look at each of the elements. 18 U.S.C. Section 208 is, in some ways, a nice statute, because essentially it's a list of elements, and we must satisfy all of them for there to be a potential violation.
That's right. If any of those elements is not satisfied, then 208 does not apply.
And then we could go and look at regulatory issues or other ethics issues that might arise based on our fact pattern.
That's right.
But today we're going to be looking in order at those elements, talking about how we would satisfy them, how we would evaluate them, so that you're really oriented to the content of the statute.
So, Patrick, what's the purpose of 18 U.S.C. Section 208?
The purpose of 18 U.S.C. Section 208 is to prevent personal interests from affecting government decision-making. So as civil servants, as public employees, as employees of the federal government, we have an obligation to make decisions and conduct our work with the public's interest and the national interest in mind. And we have an obligation not to allow our decision-making to be influenced by our own personal financial interests. The idea is that we're here working for the United States citizens in the executive branch, the federal government, and that we shouldn't be working for our own personal interests. So that's kind of what we're talking about when we're talking about conflicts of interest.
That's right. And there is a common misconception with 18 U.S.C. Section 208 that I'd like to talk about right now. 208 does not bar the holding of any particular kind of asset or asset class. 208 does not say that you can't have stock, you can't have bonds, you can't have real estate, you can't have credit default swaps. You know, whatever it is that that you have as a financial holding, 208 doesn't say you can't have that. What it does say is that you can't participate in any particular matter in which you have a financial interest.
Right, so if there's a government matter that you're asked to participate in, and in that matter, you have a financial interest in that matter, the outcome of the matter would affect your financial interest personally or the interests of persons whose interests are imputed to you, you are barred from participation. So what we have here is a bar on participating in certain government matters. And when we say participation, we mean official participation. It's understandable why people can get confused and think that maybe this is a bar on holding certain kinds of assets.
And to be fair, there are certain organic agency statutes and supplemental regulations that do bar specific kinds of assets from being held by that agency's employees.
Right, and those things are conceptually linked. But the authority for those prohibitions on holding certain assets does not come from 18 U.S.C. Section 208.
That's right.
It's either in a supplemental agency regulation or in an organic authority. So we want to make sure to keep those things separate in our minds. So just remember, when we're talking about Section 208, we're talking about a bar on participation. So let's look at the two elements that we're really focused on. You know, when we're brass tacks simplifying 18 U.S.C. Section 208, What are we concerned with, Ryan?
So what we're concerned with is when an employee is assigned to a particular matter, and we're going to break particular matter out into a lot more detail in just a few minutes here. But what we're talking about is when the employee is assigned to do a particular bit of government work, official capacity work. And when you couple that with that particular bit of government work having an effect on the employee's own pecuniary interest, that's where we have a problem. That's where we need to worry about the employee participating.
So if we were to summarize this in just a sentence, what we're looking for here is the nexus between a particular matter, so a government matter that an employee has been assigned, and the employee's personal financial interests. So if we have an overlap between the government matter and the employee's financial interests, we need to be very careful because we may have a criminal conflict of interest.
That's right, and that's the main thing that we do as ethics officials is prevent criminal conflicts of interest. We are a prophylactic entity.
That's right. So usually we'll be advising employees about upcoming work or advising them based on their financial disclosure reports. All right, Ryan. So we're not alone here. We don't have to memorize the statute. We have the text of the statute available to us. We have the regulation, and we have a number of OGE legal advisories. So let's take a look at where we should start when we're conducting our analysis under 18 U.S.C. Section 208.
Okay, so the first thing that we've got is the compilation of federal ethics laws.
The compilation of federal ethics laws. And going to the text of the statute is always an excellent place to start. It makes sure that you understand how the elements fit together. It ensures that you're looking at the right place. We're talking about a criminal law. Mm-hmm. So because we're talking about a criminal statute, I think we owe it to our employees every time we advise them on a criminal law or any of the ethics regulations to take a look at the text of the regulation. The problems we run into and we see in agency ethics programs and advice and counseling often come from trying to practice from memory.
That's right. If I had a quarter for every time that when I was a desk officer I had an agency call me up and start quoting the text of the statute or the regulation from memory and get it wrong, I would have a big stack of quarters.
You would have at least a few quarters.
Yeah.
Yeah, so it's really important to start with the text, and when we teach these things, we focus heavily on the text. So let's take a look at 18 U.S.C. Section 208 in the compilation, and you'll find this on page 19 of the statute. So if you're brand new to the practice and you have this book, that is where you'll find the text of the statute.
If you don't have this book, you can also look on OGE's website under the Statutes and Regulations tab to find all of the statutes and regulations for anything that is ethics related that OGE is in charge of.
And once you take a look at the text of the statute, you're going to find that some key terms, some key elements jump out at you. And then you're going to look around and say, well, I'd really like to know what these terms mean. You're going to find that maybe you have some definitional problems. You know, what's a particular matter? What does that mean? Mm-hmm. What's a financial interest? What's an imputed financial interest? Where do we find the definitions for these elements? And OG has helpfully issued a regulation, an implementing regulation for 18 U.S.C. Section 208. And you can find that in the Code of Federal Regulations. And you can find it at 5 CFR 2640. That's the best place to look. We do cover it in some detail in 2635. That was the earlier implementation. But really, when you're looking for regulatory guidance with respect to 18 U.S.C. Section 208, look at 5 CFR 2640. What are we going to find there, Ryan? We're going to find a number of things, right? We're
going to find definitions for all of our terms.
Enormously helpful.
Yes, that is enormously helpful.
So the definitions are extremely helpful, and I think when you're in your ethics practice, when you're advising employees, you'll find that usually the answer to your question turns on a definition. Mm-hmm. But 18 U.S.C. Section 208b2 also gave OGE a special authority, right?
Right. It gave OGE the authority to create to create exemptions, and also to create waiver guidance.
Yes. So if you think you have a conflict of interest, there are some exemptions for certain kinds of financial holdings that you can find at 5 CFR 2640. And the authority that OGE received from Congress to issue those regulations is found in 18 U.S.C. Section 208b2. You can also find guidance on issuing waivers. So if you get to the point where you need to remedy a conflict and you think a waiver might be appropriate, you can find that guidance also in 2640.
Just remember, if you're thinking that a waiver might be appropriate, call your desk officer first.
Yes, because you must always consult with OGE on your waivers where practicable.
That's right.
So you're not without resources or tools, and we want to make sure that you keep in mind that those are available to you.
And again, if you don't have either of these books, you can find you can find the statutes and the regulations under the Statutes and Regulations tab on OGE's website. You can also find the last thing that we have listed as a primary source are legal advisories, and you can find those also under the Legal Advisories tab on OGE's website.
That's right. And there's some very helpful ones.
So let's go ahead and get back to...
Let's get back to the slides.
Yeah.
Because we want to make sure that we have time to get through all of the elements. This is really a lot to cover in just 2 hours. So here you'll see a list of the key elements of 18 U.S.C. Section 208. We have employee, so this is the people to whom this statute applies.
We also have particular matter, which is going to talk about what kinds of government work would be applicable with 208.
Also known as the hard part.
Yes.
We have financial interest and imputed financial interests, which are more straightforward but can be fairly complex in some circumstances.
Sometimes.
We have direct and predictable effect. So this is about the relationship between the particular matter and the employee's financial interest.
And then lastly,
finally, we have
personal and substantial participation.
Yeah, which I think is one of the easier elements, but is certainly one that we need to consider.
That's right, and you can get tripped up with that one too.
Yep. And we're going to just start working through this list, and we'll see how far we get this morning, and then we'll take our break at noon, and then we'll come back at 1 to finish up the list and talk about some remedies.
So what do you think the first one we're going to talk about is, Patrick?
I was thinking we would start with financial interests.
Actually, no, we're going to start with employee.
Is that because it's at the top?
Yes.
I think that's sensible. I like your idea better.
So let's go ahead and start talking about an employee. So here's a question. Who's subject to 18 U.S.C. Section 208, Patrick?
If you work for the executive branch of the government, you're probably subject to 18 U.S.C. Section 208.
That's right. All executive branch employees.
All executive branch employees. So that includes our non-career officials, the special government employees.
Presidential appointees, all of them.
Yes.
Everybody.
Governmental Personnel Act. So if you have people detailed to your agency under the IPA, those people are subject to 18 U.S.C. Section 208. Who is not covered, Ryan?
Contractors are not covered. And why do you think that is, Patrick?
Because they're not federal employees?
Yes, that's right. That's right.
So they're not. And that's not to say that there are no ethics provisions that may apply to contractors, but the mechanism for that is not the criminal conflict of interest statute.
That's right.
Your agency may have other policies or contracting mechanisms that set standards for those contracts, but that's not what we're talking about when we're looking at 18 U.S.C. Section 208.
That's right. And usually this is almost always going to be one of the easiest elements to answer, to satisfy. Is this person an employee of the executive branch? Yes or no? It's
also a really important one to start with.
Yes.
I've had a number of cases where I've been talking to an ethics official in my capacity as a desk officer, which I used to do here at OGE, and you work through a really complex potential conflict issue, and then you find out that the employee is not an employee.
I hate it when that happens.
I hate it when that happens too.
Just spent 2 hours looking through all of the other elements.
Right.
And they're like,
except this, does it matter that this person isn't a federal employee?
Yeah, they're a contractor. Like, well, yeah, it matters.
Yeah, it matters. So it's a good threshold question. It's a good place to start. A good question to ask, and also usually a fairly straightforward question to answer.
That's right. So that one's pretty simple. So let's go ahead and move on to the next one.
So now that we're done with the easy part, let's get into the hard part.
Yes, the hard part.
So here we're talking about particular matters, and if there was an element of 18 U.S.C. Section 208 that OGE spent more time on than any of the other elements when we're contemplating advice for agencies or published advice or training or tools, we spend time thinking about particular matters.
Right, and there's a couple of different kinds that we're going to break out here, but in its sort of statement of what particular matter means, we're only talking about matters that involve deliberation, decision, or action focused on the interests of 2 different kinds of things.
Right.
We're talking about specific persons, and we're talking about a discrete and identifiable class of persons or entities.
And we've created sort of an intellectual framework to help us deal with these 2 categories. When we're talking about the specific persons, we call those particular matters involving specific parties.
Right.
And I think these are relatively easy to understand.
Yeah, they're much simpler because they're based on specific people.
And they're relatively intuitive as well, I think.
Right.
And that's one of the important concepts to take away is the degree to which these are intuitive concepts.
The much harder one is what we like to call particular matters of general applicability.
And these are much harder. These are the matters that are focused on a discrete and identifiable class of persons. And I find it difficult to even start to separate these in my head without a few examples.
Right.
So let's start with a couple of examples of particular matters involving specific parties. So these are easier. What kinds of things are we talking about, Ryan, when we talk about particular matters involving specific parties?
So we're talking about like contracts. Or
contract. That's straightforward. That's something we think about when we think about conflicts of interest.
Right, because what are we talking about with a contract? We're talking about at least two people. Okay. We're talking about a specifically named person who has a contract with a specifically named person.
Yes. So yeah, definitely contracts. Other agencies, it's fairly straightforward. Things like litigation. Mm-hmm. If you're going to be going to court for some matter on behalf of the government, and there is a counterparty, then you have a particular matter involving specific parties. Mm-hmm. So litigation is definitely a particular matter involving specific parties.
What about grants?
I think grants look very much like contracts. Mm-hmm. We have someone who's going to be receiving money from the government. That's a person that we can name. That's something that I find helpful is when we're talking about specific party matters. These are matters where we can name the party to the matters. So you can be a party to a particular matter involving specific parties. That's kind of one of the important considerations. And if 18 U.S.C. Section 208 stopped with specific party matters, I think it would be fairly straightforward. I don't think this would be an 8-hour class when we teach it to new folks in the classroom.
Right.
But we also have these other particular matters. We have the particular matters of general applicability, which are distinct from our particular matters involving specific parties, which are focused on individual persons. They typically involve individuals. But these particular matters of general applicability I find to be much harder.
I do too, because what are we talking about? We're not talking about, I can't just say, okay, we have a litigation between the U.S. government and Patrick.
Right.
We're talking. There has to be a discrete and identifiable class of persons. There's not any specific person within that class named.
Yeah, and I think that's the concept that's really difficult. But this is where we get to things like rulemakings, mm-hmm. Policy kind of decisions that are focused on discrete and identifiable classes of persons.
Regulations.
So that the question that always comes to mind here is what does it mean to be a discrete and identifiable class of persons? What is that? Can you give us an example, maybe, Ryan, of a discrete and identifiable class of persons?
Sure. So let's say that we work for an agency that regulates regulates mobile freight on trains.
Okay, so we're looking after the trains.
Right.
Railroad industry, moving freight.
Right, and so let's say that we're going to create some regulations governing railroad freight safety.
Okay, so we're going to do safety regulations for companies that run trains on the railroad to move freight around.
Right.
So are you suggesting that the companies that move freight on the rails in the United States are a discrete and identifiable class?
I would say so, yeah.
That makes sense to me. I think that's discrete because there are a finite number. Mm-hmm. We can identify them. They're railroad companies. So that rulemaking would be a particular matter, and in this case specifically, it would be a particular matter of general applicability.
Right.
And I've seen this example used in some other cases, and people say, well, isn't that a specific party matter, really? Because if you look at freight rail companies in the United States, we have Norfolk Southern, we have CSX, and just a handful of others. So you could probably count on one hand the players in the freight rail industry in the United States.
That's right.
Doesn't that make it a specific party matter?
It doesn't, because the regulations don't specifically say safety regulations for CSX, safety regulations for Pacific Southern.
Right. So if I started a freight rail company tomorrow, I would become a member of that discrete and identifiable subject to that regulation.
That's right. Patrick Railways Inc. would be subject to the regulation, even though you weren't specifically named in the regulation.
Another way I like to think about this is you can't be a party to most rulemakings. Unless you have a negotiated rulemaking or something funny like that. In most cases, when we're talking about rulemakings affecting an industry or a discrete and identifiable class, there aren't parties to that rulemaking.
Right.
So then we know we're in the area of particular matter of general applicability. But when we're talking about Section 208, it applies equally to both specific party matters and particular matters of general applicability. So it's broad enough to encompass both of those categories.
Right.
It is important for Section 208, though, to understand which kind of matter we're talking about. And why is that, Ryan?
Well, the reason why is because there's going to be certain kinds of participation and exemptions that are available depending on which kind of matter you're working on.
That's right. So when we look at 2640 and we get into our regulatory exemptions, you'll see that some of those apply specifically to particular matters of general applicability,
Right.
and others to specific party matters. So it's really important, even though the statute itself covers both, to know which you're talking about. Mm-hmm. Also going to be really important tomorrow when we talk to Cheryl about Subpart E of the standards.
Right.
Because that deals primarily with specific party matters. All right, so I'm feeling better about that. Can we think of another example of a particular matter of general applicability?
Sure. Let's, since we're talking about regulations, tell me what you think about this, Patrick.
Okay.
Tell me if you think that this is a matter of general applicability.
All right.
So let's say that we work for the IRS.
Okay.
And we're going to create a new tax regulation that governs all businesses that have less than 50 people.
Okay, so we have the small businesses employing fewer than 50 persons.
Right.
And we're going to give them or take away a tax break?
Yeah.
Something like that?
Yeah.
And the question is that a particular matter of general applicability?
Right.
It's an interesting question because I think when we're looking at discrete and identifiable, that group of persons, that group of companies is identifiable. Mm-hmm. We can put a name on it. We say, businesses employing less than 50 people. But on the discrete prong, I think maybe we have a bit of a problem because I can be involved in any kind of industry or any kind of service provision and have a business of less than 50 people. In fact, I think more than half of businesses in the United States have fewer than 50 employees.
Right. So what we would be capturing there would be a group that's too broad to have any kind of discreteness to it. It would capture Patrick Railways, Inc. and also, Ryan's food truck.
That's right. So yeah, we would have that's too broad a category. So a change to the tax code applicable to small businesses would not be a particular matter of general applicability. It certainly wouldn't be a specific party matter. So that would be something else, right? It would be a broad policy matter. Mm-hmm. So that would be outside of the purview of 18 U.S.C. Section 208.
Right. And in that example, what we're talking about there is a matter that was focused on a large and diverse group. I think that word diverse is an important way to think about it because
that
diversity...
Because when we look at the 50 employees, the businesses with 50 employees, they're extraordinarily diverse.
Right.
They're engaged in almost every business or industry in the broader economy. Mm-hmm. They're not discrete. They may be identifiable, but they're certainly not discrete.
Right, and so that's just another way to think about it, is to think about, not to say that you couldn't have a matter of general applicability that doesn't involve a diverse number of entities, but the diversity must be very, very narrow. You're talking about a specific subset of something generally.
So usually we're talking about an industry group. So
Right.
we're talking about regulations or other government matters that affect the railroad industry, mm-hmm. or maybe the telecommunications industry, or maybe cell phone service providers. So we're talking about industry groups. That's kind of where we find that line between the broad policy and discrete and identifiable class.
Right.
And I think it's important to focus here also on the evolution of matters through the government. Could we take a look at the triangle again, Ryan?
Sure.
And this is something that is a practical piece of information for folks who are advising employees on particular matters and on financial conflicts of interest. And that is, at the time the employee approaches you for advice, be that financial disclosure filing season or they come to you with a specific question, you may not have a particular matter. That element may not yet exist in your agency. But it is very possible, and it is sometimes foreseeable, that a particular matter will arise. And it's important to sensitize our employees when we're advising them of that possibility. So come with me on this example.
Okay.
So say, Ryan, that you were an employee and you came into my office and as your ethics official, and we worked at a financial services regulatory agency. So say we're an agency that regulates financial services providers.
Okay.
And we're concerned about risk. We're concerned about risk in the broader economy. And we want to focus our regulatory efforts in the next 2 fiscal years on managing and mitigating risk in the financial services Okay? So our first step, and this is where you came to me, is when you were assigned to work on this, is to do a study of the entire industry. The provision of all financial services products. Everything from auto loans to derivatives and mezzanine debt securities.
To annuities and everything.
Bank accounts, checking accounts, money market funds, the whole industry of money.
Yeah.
And find areas of risk.
That seems awfully broad to me.
I think that's plenty broad.
Yeah.
We're easily going to be in the broad policy area. But it's foreseeable to me as your ethics official that we're not going to do nothing with that information. You're going to go out and work on this broad study with a bunch of colleagues, and you're going to come back and you're going to share your findings. And you're going to produce this report. Well, we're going to do something with that report probably.
Of course.
So we're going to set a rulemaking agenda. And at this point, we might cross that line from broad policy into a particular matter of general applicability.
Could you give me an example of that?
Sure. So say we look out at the financial services industry, all the financial services, and say we find that there's a lot of the economy in the area of retail-provided credit cards.
Okay.
All right. So retail firms that provide credit to employees or to consumers, that there's risk there in the provision of those credit cards. And we decide that that's particularly the case in large retailers, retailers like department stores.
Okay, like Target, Walmart, Macy's.
Things like that, yeah. And we decide that we want to explore rulemaking to tighten their credit standards or change the way they do business.
Okay.
We may be moving now from the broad policy to the particular matter of general applicability.
I could see that.
We may be beginning to think about a regulation that would affect large retailers that provide credit cards. And that may be a discrete and identifiable class of persons.
And if it is, then we've moved into 208 land.
Then we've suddenly moved from a broad policy matter into 208 land.
Right.
And say we continue down this path. We make the rule. We do the rulemaking. We issue the rule. And then later it's time to take an enforcement action against one of these organizations because there's a violation of this new policy.
Right.
And then you're asked to consult on that enforcement action. Well, the enforcement action, the investigation itself, is a particular matter involving specific parties.
That's right, because you're talking about the U.S. government on one hand and a specifically named entity in the other.
That's exactly right. So I think when you have an employee who comes to you and you don't yet have a particular matter, take a moment to think about whether you can see one evolving so that you can advise your employee of the need to come seek further counsel as the work evolves. That's one of the really difficult things for employees to do, is once they've received an initial piece of counseling, to know when they have to come back and get further counseling, to know which facts of the matter change the analysis.
That's why it's very important for them to know who you are as the ethics official at your agency.
Yeah, and this is a difficult concept, so sensitizing them to that fact is a good thing to do. It's hard for ethics officials to understand these categories. It's even harder for our employees.
Right.
So that's just something to keep in mind. So do you think we've sufficiently talked about particular matters? I think we could probably talk for the rest of the day about particular matters.
We probably could. I think the main the important thing to remember here is take a minute to sit down and sketch this triangle out, because I think that this will be helpful for you later on. The main thing to remember is that the difference between specific party matters and matters of general applicability, and the ability to sort of move in between those and sort of float into more and more specific kinds of particular matters.
Yeah, I find it useful as an exercise during this class to sit down and think about some examples of specific party matters at your agency. That's usually pretty easy. And then think about any particular matters of general applicability that may arise. And see if you can do that exercise. And if you have difficulty, we have some guidance. Ryan mentioned before that we have a number of legal advisories. We have a fantastic legal advisory on particular matters, which you can find on our website under the Legal Advisory tab. You can just select the particular matters in the search box there, and a number of opinions will come up, and the more recent ones are fantastic on explaining to you the difference between these kinds of matters.
That's right. They will explain them fairly exhaustively.
Yeah. Or at least enough so that you know when you're close to the line and you need to call your desk officer at OGE.
Right.
All right, well, shall we move on? We have about 25 minutes left, and we might be able to get into financial interest a little bit.
Yeah. Okay, so we're talking about financial interest or imputed interest for this next element.
And this is an area where I really like to take a look at the text of the statute, because I find it to be really helpful.
So if you have your statutes ready, go ahead and take those out and just read it to yourself real quick. We'll give you 30 seconds or so.
Yeah, we'll give
A minute?
A minute or so.
A minute?
To find that. If you're using the compilation book, it's on page 19. If you're using the web version, it's under the Laws and Regulations tab.
Right.
So we look at this. We see some information about what an employee is, what it means to participate. We have a discussion of a particular matter. And then finally here we have in which, to his knowledge, he, that's the employee, his spouse, minor child, general partner, organization in which he is serving as officer, director, trustee, general partner, or employee, or any person or organization with whom he is negotiating or has an arrangement concerning prospective employment, has a financial interest. So we are not just concerned about the employee's own financial interests in the particular matter, are we, Ryan?
No, we've got a small galaxy of other people whose interests that we are concerned with here.
Yeah, and that's that can be a difficult issue for us when we're advising employees, because we know when we see on the financial disclosure report, some of these people's interests have to be reported on that financial disclosure report.
That's right.
But not all of them.
Not all of them.
Well, that's interesting.
Yeah.
So does that mean we're going to have to sometimes seek more information in order to rule out a potential conflict, or advise an employee they can't participate because they have a conflict?
I think that we have a duty and obligation to, since this is a criminal statute.
Yes, so it's not enough just to have the information on the form, though the form's information is very, very helpful. There may be some things on the form that tip you off that you need more information, so just remember that. We have to consider all of those persons' interests before we can advise an employee that he or she is free of potential conflict.
Right. So what's a financial interest to begin with?
Let's take a look at the slide here. And I think this is an area where people get confused because, in some ways, the way the law is worded and the way the regulation implements sort of a strangely worded law. We say in the statute that we can't participate in a particular matter, which we just talked about, in which the employee or those list of persons whose interests are imputed to the employee has a financial interest.
Right.
So the financial interest is in the matter, which is complicated, because I think when we think of financial interest, actually what we're thinking about is something like a financial holding.
Okay.
When we have things reported on the 450 or the 278, we have stock holdings reported. So I own stock in Dell. Well, my stock holding in Dell isn't itself a financial interest for purposes of 208. It's a holding. But it can create a financial interest in a matter that would affect Dell.
Right.
So the financial interest is really the potential for gain or loss as the result of government action. So if any of these people listed here could gain or lose as a result of the particular matter, the employee may not participate. And the employee can get financial interest personally through ownership in stocks, bonds, and other financial instruments. They can gain financial interest in particular matters by virtue of having arrangements concerning future employment. But the matter is in the interest, so we always start with the particular matter. That's why we take that as our second element here. The employee is always going to be a threshold question. You know, are you or aren't you subject?
It's yes or no.
Yes or no. Particular matter is the next one we talk about, because it is the one from which all of the elements, they sort of orbit around and relate.
Right.
So we have to start with the particular matter, and then we can get into the financial interest. And a financial interest is the potential for gain or loss as the result of government action or as the result of a particular matter.
And I can understand how this could be a little confusing to some people, because financial holding and financial interest, like saying that you have a financial interest is a common way of saying that you own something.
That's correct.
Whereas it is a very specific meaning that we have within 208.
Yes, it's specific to 208. It's also broader, right? You needn't own a financial instrument to have a financial interest in a particular matter.
Right.
You could have a direct financial interest in a particular matter. You know, maybe you'll receive some direct gain or loss, or maybe your spouse will receive a direct gain or loss, or your dependent child, or someone with whom you have an imputed interest. So whose interest are we talking about here, Ryan?
So we're talking about two different kinds of interests. The first one we're going to talk about is a personal interest, and then we're going to discuss imputed interest. So for a personal interest, what we're talking about is the employee, him or herself. and that interest could exist in a particular matter through financial instruments such as stocks, bonds. You mentioned Dell earlier.
If I think they're a private company now, so you probably don't have stock in Dell anymore.
Actually, yeah, that's true. But if you have stock in Intel, for example,
yes,
and you're the chief information officer at a federal agency, and you're trying to decide whether to buy a bunch of Intel chips, and then you own stock in Intel.
The stock would create the financial interest in the particular matter.
Right, we would have a nexus.
Is the contract. So the particular matter is the IT contract. The financial interest is in that matter as a result of ownership of Intel, the chip maker.
Right. And it doesn't just encompass financial instruments like stocks. It also comes from other kinds of investments like real estate. It could come from
other kinds of complex financial instruments.
Right.
You could have real employment interests, so maybe you have restricted shares from a previous employer, or you have stock options, or you have a payout that is supposed to be made at some future time. You could just have a receivable,
right?
And that could create a financial interest in a matter,
right? And the last one is outside employment,
right? So we have we have two things explicitly in the statute. It says that the financial interests of your outside employer are imputed to you,
right?
But also you can have a direct interest in outside employment. So you have an interest in the continued receipt of your salary or benefits, or any other kind of benefits that you enjoy as a result of outside employment, in addition to the imputation of your outside employer's interests to you as the federal employee.
Right. So like we said, these are these are the interests that are personal to just the federal employee. But as we mentioned a minute ago, there is a small galaxy of other folks whose interests are imputed to the employee. And when we say imputed, what we mean by that is we treat those interests of those other persons as the employees for purposes of 208.
As if they were the person almost stands in the shoes of these other persons.
Right.
Yeah. So let's take a look at that list again.
Okay.
So we have the spouse. This one's pretty straightforward. If an employee's spouse owns stock, we treat that the same as if the employee, him or herself, owns the stock. If the spouse has a receivable, we treat that as if it's the employee's.
Right.
If they have other kinds of financial instruments, we treat them as if they're in the employees. This is why when we look at the financial disclosure reports, the spouse's assets must be reported the same as the employees. And we don't make any distinctions in our analysis between those. We treat the spouse's assets and holdings as if they were the employees, and they have the same capacity, the same possibility of creating a financial interest in a particular matter.
And just like the spouse, the same goes for minor children of the federal employee.
Yeah, and it's a little complicated because we require the reporting of dependent children, and 208 is the minor child. But just remember, it's the minor child for purposes of Section 208.
Right.
Again, their holdings we treat as if they're their employee's own.
Now, what's this about the general partner of the employee, Patrick? What does that mean?
See, this is tricky because we don't mean the general partnership. The general partnership's assets are the employees, if they're a partner. So we treat those as the employee's own. But we also reach to the financial interests of the general partner, him or herself.
Wow.
So their interests outside of the partnership, so their personal stock portfolio, their real estate assets, their other financial instruments, we treat as the employee's own for purpose of Section 208. They're explicitly in the employee. So that's tough because I don't think those get reported on either of the financial disclosure reports.
Well, I mean, how do you know?
The partnership itself is usually going to get reported.
Right, because if I'm a general partner, I know what my general partnership has.
Right, so I'm going to report that partnership as an asset on Part 1 or Schedule A. I might have a position with the partnership, which would go later on in the form. But then we'd have to inquire about the partnership and potentially the partner's asset. We do have some sensible regulatory relief here. When we were talking earlier about 18 U.S.C. Section 208b2, we said that OGE was authorized by Congress to issue some exemptions for certain kinds of financial interests. The area of general partnership is an area where we've done this. So if you have a situation where you're concerned about a general partner's personal assets outside of the partnership, take a look at 2640, because there's some fairly broad regulatory relief that takes away most of the absurd results here.
That's right. So the next one we've got is an organization where an employee is an officer, director, trustee, general partner, or employee, and you'll notice that this mirrors this is directly from 208, and these are basically outside positions.
Right. So if an employee has an outside position, the employer or organization's interests are all imputed to the employee.
Right. So let's say that I have an outside position teaching at Harvard University,
Okay.
which has one of the largest endowments in the entire world.
Does that mean we treat that whole endowment as if it was yours?
Yes.
Okay. That's fairly straightforward.
That would be very difficult to figure out what all is in that endowment because they won't tell you.
Yeah, but that's an interesting case. But that's important because your outside employer or an organization where you serve as officer, director, trustee, general partner, or employee, all of their interests are imputed to you as the employee.
Right.
And we need to consider those. And again, they're not all going to appear on the 450 or the 278. So we may have to ask some questions in order to provide thorough and complete advice.
And if you're wondering whether or not an outside position might be captured on here, a very general way to think about it, I'm not going to call it a rule of thumb per se, but a general way to think about it is where you're talking about an outside position in which the employee has a fiduciary responsibility of some kind. Generally speaking, that's going to be captured under 208.
Yeah. Okay. And then we have this last category. We have persons or organizations with whom the employee is negotiating or has an arrangement for future employment.
Right. So that means that if I get tired of working at OGE and I want to go work somewhere else, say for a private corporation, that means that corporation's interests are going to be imputed to me.
That's right. During the time that you're negotiating and have an arrangement.
Right.
We also have sort of a regulatory hurdle that we put up to prevent problems here, the Seeking Employment Regulation, which appears in the Standards of Conduct, which has a broader category of arrangements where we have an imputation, but it's merely regulatory. But if you're looking for guidance on to implement this, look to the standards because that's very helpful.
Right, because the threshold for requiring a recusal from participation is lower in the regulation than it is for 208.
All right. So that's the general universe. Let's talk about imputed gain or loss. So the question we have is, will the government action, will the particular matter, result in a possible gain or loss to interest imputed to the employee? So if I work for Harvard, will Harvard gain or lose as a result of this particular matter? If I have shares of Intel, will Intel gain or lose as a result of this particular matter? Will my spouse gain or lose as the result of this particular government matter? Will my minor child, my general partner? So the question is, will that person whose interests are imputed to the employee, will they experience a gain or loss as a result of the government action? And it's important here because that's the government action. It doesn't have to be the employee's action particularly. So they are prohibited from participating in any particular matters that would have a direct and predictable effect on the financial interest.
One other thing that I would like to point out here is these words gain or loss.
Yeah, we don't have to be helping the people who
right.
We can
we can be hurting them.
Yeah, they could experience a loss, and we're still prohibited then from participating.
Right. There is no basement or bottom threshold for 208. It goes. You can go into the negative all you want to on 208 because losses are covered by it as well.
Covered. That's correct. Let's talk a little bit about spouses' employment interest.
I think that's a good idea.
I think this is hard. You'll notice that in the list of persons whose interests are imputed to the employee, we do not see the spouses. And that's kind of tricky. So if the spouse has a pure employment interest, right, so they have no equity in the employer, so there's a standard...
so they're just drawing a salary.
Drawing a salary or an hourly wage, no stock options, no other equities, no retirement, none of that. How do we deal with that under Section 208? Whose interests are imputed?
Well, we know for sure that the spouse's interests are imputed, but I don't know, because the spouse does have an interest in employment at wherever he or she's working.
That's right. So for purpose of 208, we look at the spouse's personal interests. And where does the spouse's interest lie? It lies in the continued receipt of that compensation. It rests in their continued level of compensation and their continued employment. So we talk about the spouse's employer if we don't have any equities involved, no equity interest in the employer. We don't have any thing in addition to the salary or hourly wage. We look at the spouse's personal interest.
Right.
So if the government matter could affect their level of compensation, we might have a problem.
Let's maybe do a direct comparison between a federal employee and a spouse.
Okay.
I think that would kind of help draw this point out just a little bit more.
I think that is sensible.
So if we've got a federal employee who does have an outside job, outside employment, then we do take that outside employer's interests and impute those interests to the federal employee.
Okay, so our employee has an outside job with, let's say, Google.
Okay.
All right, so all of Google's assets, everything that Google has financially, all of their financial interests, we treat as if they're the employees.
Right.
Simply by virtue of that outside employment relationship.
Mm-hmm.
Okay? I think I'm clear there.
Yep.
So how does that differ with the spouse?
Well, so with the spouse, the employer's interests are not directly attributed to the employee. The spouse's interests are, but the spouse's employers are not. There's not a double imputation.
There's not a double imputation there. Mm-hmm. So we have to look at the spouse's specific interests, the spouse's personal interest. So what would that be? Well, in the case of our salary employee, it's the continued receipt of salary, the compensation level, and the continued employment.
Right.
So let's say the spouse was an hourly employee at a contractor of our agency.
Okay.
And we're thinking about canceling the contract with that contractor. And we think that that's one of maybe 2 or 3 contracts that contractor works on.
Oh, so that might actually cause that contractor to lay some people off or maybe even go out of business.
Right. So is that what we're talking about here? That would be a kind of particular matter that would have a direct and predictable effect on the spouse's financial interest because it might cause her to be laid off or compensated at a lower level?
I think that's possible, yeah.
And we have some special words that we use when we're thinking about these kinds of arrangements. What are those, Ryan?
So the words that we're looking for are ability and willingness.
Okay.
And what we're talking about is an employer's ability or willingness to continue compensating the spouse.
That's right. Okay, so if the particular matter would have an effect on the employer such that it would affect their ability or willingness to continue to employ the spouse or to continue to compensate them at the current level, then we might have a conflict under Section 208.
Right.
I think I understand that.
Okay. Now, I want to throw a monkey wrench into this, though.
Oh, please no monkey wrenches, Ryan.
I'm sorry. Stand ready. I'm going to throw it now.
Okay.
So let's say that so I think it's pretty clear that if we're talking about just straight employment interests, nothing else added to it, just drawing a salary or an hourly wage, we're talking about an ability or willingness to await potential conflict.
Okay.
Now, let's say that the spouse's compensation is tied to the profitability of the company.
All right, so now the spouse has an interest in the profitability of the company overall.
Right.
I think then any government matter that affected the company would affect the spouse's financial interest.
Right, I agree with you.
So we'd have something like a stock interest, where we would just treat the company's assets, the company's financial interests, as if they were the employee's home.
Right.
Notwithstanding the fact that this relationship is imputed to the employee through his or her spouse.
Right.
Okay.
That's why this is one of the most difficult things to analyze, because there's there are hundreds of ways that people can be compensated by companies.
Yeah, I think during the break I'm going to come back and listen to this again and make sure I understand it correctly, because it's pretty challenging.
Yeah.
But have we reached a good place to stop?
Yeah, I think we have. We've got 2 more elements that we need to talk about, but we're not going to get to those in the next 5 minutes.
Okay, so let's take a break here, and we'll come back at 1 p.m. Eastern Daylight Time, and we will discuss direct and predictable effect, as well as personal and substantial participation. We will also have some time to discuss remedies, and I think we're doing pretty well for time, so we may be able to go into some detail about the ways that we would implement a remedy to a possible conflict of interest, and get you prepared for the discussion tomorrow about Subpart E of the standards.
I hope we get to spend a little bit more time on remedies. That's one of my favorite things to do training on.
Yeah, absolutely. So we're going to leave you guys for a short break. We will be back at 1 p.m. We thank you very much for joining us and hope that you found this hour to be a helpful orientation to the conflict of interest statute, elements 1 through 4, or 1 through 3, and we'll be back with elements 4 and 5 in a few minutes. So thank you very much.
Thank you.